you're going to hear the word discovery thrown around throughout the family law process. And discovery is all of the things that need to be discovered about a situation. So for example, there is mandatory disclosure in the financial affidavit. That's discovery. There are requests for production, and that would be a request that we would send to the other party asking for specific documents, and we need those documents to figure something else out. So that would be a request to produce. Then we have interrogatories. Interrogatories are direct questions about something. For example, why do you believe equal time sharing is in the best interest of the child? Or for example, what assets do you believe are non-marital and which assets are marital? So it's a series of questions that we're able to ask the other side. There are requests for admissions where you would say to a party in a question format, admit or deny that you have a bank account ending in blah, blah, blah. Admit or deny that that bank account includes this much money. Admit or deny that you had an affair. Admit or deny that your child has these certain diagnoses. And admissions are also an excellent discovery tool. Those are the kind of discovery tools that we send out. Notice a non-party production. If I need to get employment records from your spouse's employer or from the other side's employer so that I know their accurate income, or I know why they were fired from a particular job, or I know what their work history was. I can send notices of production to non-parties. I can send subpoenas out to get that information directly. We like to send subpoenas out to banks that we know there are investments and banks where we know there are accounts, because sometimes you catch a bank or an account that somebody didn't disclose by sending out that subpoena. Now, we can't cast a huge fishing net, but we can zero in on what we believe, what we reasonably believe to exist so that we can identify the assets and the liabilities. Another area of discovery is depositions, and depositions are where, as an attorney, you sit down from a party, whether it's a party to the case or a potential witness in the case, and you get the opportunity to ask questions that relate to the case. And these questions can run the gamut. In fact, there is only really one appropriate objection in a deposition, which is the objection to form. There's also privilege. You're not going to give out privileged information in a deposition. But other than that, in a deposition, you're going to answer every question that gets asked. And this is an incredible fact-finding opportunity for an attorney to be able to go from top to bottom and understand the nature of the case. It's also a great opportunity for the witness to understand, for the attorney to understand how a witness is going to answer a question, or how certain questions affect the way the witness behaves. And this is a great tool for preparation for trial. But more important, it's part of that discovery process. You're discovering something about the case that you need to use to move that case forward.